Hi there, welcome back to this course on the GDPR UK training course. Of course, the primary purpose of the GDPR and any similar legislation is to ensure that confidential data is kept secure and that privacy is appropriately respected according to human rights. To be capable of doing this, an organisation must prove itself capable of safeguarding personal data and preventing serious breaches from taking place. In most business sectors, this will be heavily dependent on the effectiveness of cybersecurity. So, without further ado, let's get started. The term cybersecurity is given to any collection of methods of technology that are expressly designed to protect the confidentiality, integrity and availability of computer systems, as well as the data that it processes. As practically all businesses and authorities rely on computers and digital mediums to store, transfer, analyse and update information, cybersecurity is the foundation of keeping it all safe. This can be based on multiple techniques and platforms, including encryption. In general terms, encryption is the activity where data is scrambled in some way so that only authorised parties will be able to understand or access it. This is a way to safeguard confidential data in a timely, inexpensive and effective manner. Data encryption is best used when it provides layers of protection to guard against unauthorised or unlawful processing. It is built into an operating system from the planning stage. It applies to individual files, storage devices, or specific applications. It can store data in a way that makes it illegible to external sources. It is reviewed and upgraded to meet the risks posed by any changes in technology or environment. The most common forms of data encryption are symmetric and asymmetric. The symmetric method uses a mathematical algorithm to create a single key for encryption and decryption. In contrast, asymmetric encryption uses two separate keys for encryption and decoding. The two asymmetric keys are known as the public key and a private key. The National Cybersecurity Centre, or NCSC, is an organisation of the United Kingdom government that provides guidance for organisations that want to mitigate computer security risks. They can provide valuable advice on the best type of encryption to use in any given system, or for any working organisation. Founded in 2016, the NCSC was brought together to promote the importance of cybersecurity and pass their available knowledge onto the organisations and bodies that need it, respond to verified cybersecurity incidents in order to reduce the potential harm they can cause to UK companies, channel industry and academic expertise into processes that nurture the UK's cybersecurity capabilities, lower the risk of criminal activities and unlawful practices that can be enacted on members of the general public by accessing their personal data. One of the biggest threats to organisational data protection is malware. This term is used to describe any type of software that has been intentionally coded or installed to disrupt computer networks. It may also be used to gain unauthorised access to private information and systems. Of course, this can be the tool by which criminals can gain a route to compromising data protection. The NCSC regularly highlights the dangers that malware represents, including the type known as ransomware. Ransomware is a variation of malware that will prevent processors and collectors from accessing their IT devices and processing any data stored on them. There may then be some form of specific demand from criminals before they arrange to return the system to normal, or there could be a warning that their data is being stolen or compromised. Invasion by ransomware or other forms of malware can result in the following: irreversible loss of personal data, lack of control over the processing or transfer of information, staff or clients being targeted for cyber attacks, illegal activity or broadcasts involving sensitive information regarding the company or its customers. The way in which an organisation reacts to intrusive cybercrimes or installs data protection will define how it complies with GDPR directives. This will be essentially important if the organisation has links with sectors providing services relating to education, healthcare, retail or financial businesses, as they are more likely to be targeted for cybercrimes. In all cases, an infrastructure must be prepared to act accordingly and mitigate the consequences as soon as possible. Preventative measures and corrective procedures concerning cybercrime can be demonstrated by considering 8 factors when it comes to data protection. Cybercriminal sophistication. Knowing what technology criminals can use to access systems and work to block it. Data leaks. Being able to quickly determine the seriousness of intrusive access into a computer system and when the authorities should be contacted. Reporting cybercrime. Contacting the ICO when a cyber attack has been confirmed and providing adequate support to apprehend the perpetrators. Alerting law enforcement. Engaging directly with law enforcement when cybercrime is detected or suspected. Recognizing TTPs. Understanding the tactics, techniques, and procedures of known criminals and ensuring that they will not work on an operational system. Disaster recovery. Mitigating or retrieving data in an emergency will be vital during a sustained cyber attack. Criminal engagement. Communicating with criminals regarding cyber attacks or ransomware is not advisable, but approaches need to be formalized in policies. Data security testing. Effective data protection can only be verified if adequate and realistic testing is performed on it. When people think of cybercrime, they probably associate it with the idea of a data breach. This is a well-used term that describes incidents where data protection has not been sufficient to prevent a serious security violation. This unwarranted access can result in sensitive or confidential data being copied, transferred, stolen, or used by an individual for illegal or immoral purposes. If a data breach takes place, it can have far-reaching consequences, which will extend far beyond the theft or compromise of information. Suppose a data breach has been verified to have taken place. In that case, the ICO must be notified unless it can be satisfactorily proven that it will not endanger any individual's rights, privacy, or freedom. As well as the ICO, unless there are mitigating circumstances, the data owners affected by the breach must also be informed. According to the contents of the GDPR, it is most important when advising data owners of a breach that the following mitigation procedures are also recommended to them. They immediately perform a password reset on their personal accounts. They change their existing passwords to ones which are new, strong, and unique. They monitor for phishing emails, unknown transactions, and any other potential and fraudulent activities on their accounts. If the ICO is contacted about a data breach, it must be on the understanding that there is a clear and present danger. A decision not to inform them will need to be justified later if a breach causes significant damage or negative effects. According to the GDPR, an organisation must communicate the existence of a breach to the ICO of a notable breach as soon as possible, which should be no later than 72 hours after becoming aware of it. If an incident is reported after this period, the organisation must also provide a justifiable reason for the perceived delay in operations. The UK GDPR stipulates that these certain details are mandatory when reporting data breaches to the ICO. These would include such specifics as description of the type of personal data breach that has occurred. This should be a comprehensive listing of the categories of data accessed, the number of individuals affected, and the estimated number of personal data files compromised. Contact details for the organisation's DPO. If this role has not been assigned to a staff member, another primary point of contact must be established and offered. Estimation of the impact which the breach could have had on data owners and the organisation. Presentation of the disaster recovery plan or risk management exercise. This should detail the efforts that the organisation is making to mitigate the impact of the breach or any associated repercussions. Comprehensive records need to be kept of any breaches, whether it is serious enough to require ICO notification or not. This GDPR considers this a mandatory commitment shown by all data processing organisations as they demonstrate accountability and compliance with UK legislation. It should be remembered that the root cause of the breach will be important, whether it is due to inadequate data security or to human error. Knowing this will allow for operational changes or actions to prevent a repeat occurrence. Following a verified breach, an organisation must show that it is capable of managing the situation and ensure that the violation cannot occur again. It can do this by fully documenting all details and associated activities, as well as reviewing its existing security measures. The GDPR also advises that additional post-breach exercises are carried out, such as arranging data protection training and security refresher courses, supporting staff members with supervision and guidance during training, amending policies and procedures so that incident reporting is effective, establishing a positive working culture of trust so that staff members will report irregularities without fear of criticism or reprisal, performing problem reviews and identifying breach risks, ensuring data protection measures are relevant and up to date. This lesson explored some strategies to consider when installing data protection or dealing with unlawful behaviour. We also covered the importance of the commitment towards the GDPR and how data breaches should be managed or prevented. These are critical components of UK legislation, but are just as important for human rights and crime prevention. Stay with us and we'll move on to the next lesson, where we will explore occasions where individuals or organisations may be legitimately exempt from the provisions of GDPR. See you soon.